Someone can have an equitable interest in your property if, for example, they're an heir. If I own one 362nd interest in your property, I have an equitable interest in that property. Are you one of many heirs? Is the property in a trust? If the property is in a trust, who is the beneficiary of that trust? What happens if the beneficiary dies? Who is the alternate beneficiary? When does the trust end? There is a trust agreement somewhere, and that doesn't have to be recorded. But there has to be a certification of trust that is recorded, that shows that the trustee has the authority to accept title to the property and to do certain things with it. Are your family members supportive and agreeable to planning for the future of your property? And this is the number one consideration in making decisions for the future of your property and your estate. Is your family supportive of this, or do you need to make plans in accordance with your own wishes and perhaps leave them out? Identify each family member's level of interest and whether that person is able to actively participate in the process. People have all kinds of problems, and children have all kinds of problems. They have marital problems, financial problems, gambling addictions, substance abuse. There are all kinds of things that can affect your children's ability to participate in the process and take an active role. And you need to recognize those things and safeguard against them. And for self-evaluation, make sure that you periodically review and update both your financial and your physical health as relates to your estate plan, and make sure that everything is accurately reflected. You need to modify and review probably every 3 to 5 years. Once you have identified each family member that's necessary to this planning, list any disabled family members. It's going to make a difference if a family member of yours who is going to inherit or who you want to inherit some portion of this property is on government benefits like SSI. If they have been since childhood unable to work and they're receiving SSI and Medicaid coverage comes with it, it's not the check they receive every month that you need, it's the medical coverage that they need, because very often they can't obtain medical insurance. So if there's a disabled family member, there are trusts that you can form in order to protect and safeguard that property from disqualifying that person for government benefits. And then spendthrift family members. We want to make sure that those creditors of that person are not coming around and taking this property. Your goal in making these plans is to make sure that you have protected and preserved that property in the way you want it to be protected and preserved. And you don't want a spendthrift child or family member compromising your ability to do that. We're going to run through the real estate basics very quickly so you'll know what we're talking about. We went through the things you need to know. Real property is a bundle of rights. Think of the old brooms where they had the bundle of switches tied together. If you own all of that bundle of switches, then you have what's called fee simple title. That means you own everything that you could own with regard to that property. You have every right there is to have with regard to that real property. Most property is owned as fee simple. They may call it fee simple absolute or fee simple property. It may vary slightly from state to state, but generally the language in the deed says the property is granted to you, your heirs and assigns forever. And depending on the state, there may be other words required, or there may not be that many words required. It used to be in South Carolina you had to have the word forever, or it created a life estate. So now if we have the word forever, it makes it a fee simple. But we have also adopted statutory language that says if we just say his heirs and assigns, that's okay. Depends on the state that you're in as to what language is required. If you have less than that whole bundle of rights, you have something that is freehold, meaning that it's not owned by somebody else and you just live there, but you may have less than that full bundle. And we've talked about the way that that property gets to you, but again, it's a deed. A mortgage or deed of trust creates an interest in property that's conveyed to you or from you, an inheritance or a court order. A court order can vest title in property in you or in another person. Deeds convey straightforward, easily identifiable property interest from one person to another. It's easy to identify the interest conveyed. It's not always easy to identify the property conveyed. Mortgages, of course, are security interests. A deed of trust is what it's called in some states, where you are giving a security interest to a lender to secure a note that you have signed, an obligation to pay. You've signed the IOU, and now you're saying, if I don't pay it, you can come take my property. And it should be satisfied or canceled when it's fully paid. Each state should have a statute that addresses when a mortgage or a deed of trust expires because no satisfaction has been placed of record. But you can imagine how many different banks we've gone through with some mortgages. It's almost impossible sometimes to track them down to get a satisfaction of that mortgage. You know that you paid it off 10 years ago, but you can't find the bank because they've merged 3 times. An inheritance, of course, is a property interest acquired through a will or by other testamentary instrument like a trust or by intestacy. If somebody that has preceded you has died without a will, they have died intestate, and the intestacy statute says where that property went and in what percentages it went there. Depending on the state, the interest in property may vest at the time of death or later. In South Carolina, there's a particular statute that says real property vests at the moment of death. Personal property has to be conveyed. Well, we have the Uniform Probate Code, which most states do have in some form. So we do have a requirement that the personal representative have a deed conveying the interest of the estate to the person who is supposed to receive the property. But because we have this common law notion that property vests at the moment of death, generally heirs will also be required to sign a deed if the estate sells property or conveys property out. And it generally requires that the estate of a decedent be probated within a certain period of time. Here it's 10 years, and that I think is part of the Uniform Probate Code. And a deed or other court order issued by the probate court is effective for passing title. So a personal representative's deed of distribution out or an order of the probate court showing that the property was an asset of the estate and that it has been distributed to the heir named or the heir who is entitled to it. Any type of judge can generally alter or create legal ownership of property. So in general, most states have a court of equity. In South Carolina, we have what's called a master in equity. Anytime an action is filed in the circuit court that concerns the title to property, it is referred to the master in equity in that county. And that judge who is sitting in equity is the judge that makes the decision about ownership of property. Some states have courts of equity where you would file a suit directly. Other states have different forms. So you need to be familiar with the court system or have a lawyer who can help you to understand the court system if you're going to be going to court to try to establish ownership of property. The probate court, of course, only has jurisdiction over the estates of decedents and those who are incompetent. So, for example, if we were going to go to court to establish legal ownership, we might bring a suit to quiet title. A suit to quiet title would just result in, we hope, an order from a judge sitting in equity that says, we've considered these things, and considering all of these things and all of these potentially equitable owners of the property, we're going to vest title in you for the following reasons. An adverse possession action. If you've lived in your little house out there for a period of time, it may have created a right of action in you to be able to gain that property through adverse possession. There are a series of elements that must be proved in order to prove adverse possession and get an order from, again, a judge sitting in equity. Actual, continuous, hostile, open, and exclusive use of the property. Cutting timber is one thing that has been used very often to establish that. Payment of property taxes. But that is an expensive proceeding.